Hello, everyone. Welcome to our third lecture in our unit on the judicial branch for our country. This is the final lecture for Chapter 11. And in this lecture, we're going to take a look at the United States Supreme Court, of which you can see in the background. All right, so let's get started. So let's start off talking about the jurisdiction of our Supreme Court. Well, firstly, our justices actually did what was called riding the circuit until 1891. So basically, what that was is that they would actually travel and hold courts in the assigned regions. So they tried it like a federal court in that specific region. They wouldn't be in D.C. Now, all cases are actually tried at the Supreme Court level, or at the U.S. Supreme Court in D.C. Now, the jurisdictions of our Supreme Court are pretty much everything. They have original and appellate jurisdiction, which means they can try original cases that are brand new, have never been seen before, or they can try cases that are on appeal. Now, generally, what are their types of cases? Well, their cases are they can deal with representations from a foreign government, as well as cases that involve states, as well as the original and appellate jurisdictions. Now, Congress can't explicitly expand or curtail the Supreme Court in any way. Part of this is through checks and balances. Now, most of the cases that get to the Supreme Court are on appeal, and we'll get into the reason why that is here a little bit later. So don't worry about why that is always the case. Now, state cases have to involve federal laws, and the Supreme Court can only rule on that federal issue. They can't rule on the state laws because there can be a conflict of interest and all that other stuff. All right. So let's talk about the justices. Now, this picture is a little outdated since there's been two new justices with Kavanaugh replacing Scalia and Barrett replacing Ruth Bader Ginsburg. We have 9 justices, and you have the Chief Justice, who currently is this man right here, Chief Justice John Roberts, and then the other justices are called Associate Justices. We varied in our history between 5 and 10, and that number can change. Congress can change that. And this is going to be something that's going to remain to be seen over the next few months and years under Biden's presidency because of 2 reasons. One, of the appointment of Barrett very quickly in the last few months, and then also the appointment of Kavanaugh a couple years ago, given the circumstances that are surrounding his appointment and whether he is qualified or not. And the same thing with Barrett, as well as how fast it was. Those are some questions that could lead to this number being changed or judges being replaced. Now, in 1937, FDR, he actually tried to increase the number of justices. His was more for control because of the government programs he was trying to institute during the Great Depression. Specifically, think of the programs he was trying to start with the New Deal. Now, the pay for justices is set by Congress, just like it is for everybody else, Congress and the president and so forth. But it can't be reduced. Now, these numbers are actually a little old, so they have been risen a little bit. Think probably a little bit more. They're closer to 200,000, maybe even a little bit more. The Chief Justice makes just a little bit more than the Associate Justices, but still, that's a pretty decent salary for their job. They can be impeached or convicted for treason, bribery, and other high crimes and misdemeanors, just like anybody else. Matter of fact, we've actually had a significant number of judges, at least early on in our history, be impeached. And again, this is something where there's a question of with the numbers and so forth as well. All right, so the duties of the Supreme Court. Their duties have developed from laws, traditions, and needs of the country. So basically, what's going on and precedent that's been established. Their main job is pretty simple. They hear cases and then they rule on the case. And they specifically have 3 tasks. They decide, go over, and look at which cases they want to hear. Once they pick a case, they'll listen to it. Then they'll make a decision on the case. We'll go through that whole process here in a little bit. And then they determine an explanation or their ruling, which is known as an opinion. And like I said, we're going to actually look at these tasks in detail later on in this unit. Now, the Chief Justice, they he also administers the federal court system. So he's not just looking over the Supreme Court and those 8 other justices, he's looking over the entire federal court system as well. And the justices themselves also look at those 12 district courts or circuits. Now, let's talk about the justices themselves and where they've kind of come from. Generally, they have a pretty traditional background. We've had 108. It's actually 108 men, and it's now 5 women serve on the Supreme Court. So I haven't updated that with Barrett being appointed there. It might be 109 men. I can't remember if I updated it for Kavanaugh or not. But anyways, it's either 113 or 114 people have served on our Supreme Court, and most of them have been white men, with the exception of Thurgood Marshall and Clarence Thomas, and then those 4 women on screen and Amy Coney Barrett. Now, generally, our justices, they've had law degrees and substantial legal experience. They've been judges before in most cases. Most of the time, they're over 50 when they're appointed. We have had a few that are younger, and generally, they're not representative of the general population. Most of them have come from the upper class. I mean, you got to think about it. Where are they coming from? They've been lawyers, they've been judges, law professors, and so forth. You do not have to be a natural born citizen to be a Supreme Court justice, because you're not going to serve. You can't serve as president because you're appointed for life unless you resign. So we've actually had 6 judges that weren't natural born to the United States but became citizens later. Now, another group that we want to talk about really quickly are law clerks, because their job is important for the justices as well in making sure their jobs are completed successfully. They assist the judges, they read appeals, they write memos. They even may write the actual opinion with the judge, or help the justice write the opinion for the court, or their specific individual opinion. A lot of times, law clerks actually end up becoming judges or hold jobs in the field of law, and may even become a Supreme Court justice later on down the line. All right. So for those of you here, real quick, I will actually give this to you guys, the actual file, so you can click this link and watch this video. We won't watch it here in this lecture, but let's go over the appointment process. We've kind of already talked about this a little bit, but we'll do it again and discuss it in a little bit more detail. So Supreme Court justices, when there's an open position, they're nominated by the president. From there, they're approved by the Senate. Most of the time, the people that are nominated by the president and get to that process are approved. But occasionally, you do have instances where they are shut down. Generally, that happens where or when a president has a different political affiliation than who's in control of the Senate. But it can happen for other reasons as well. Now, we have lower court judges. Generally, they give political considerations on who should be appointed, or even looked at to get together a list. Now, like I said previously, generally your selections are based on party lines, and usually when considerations are used, they're done as a favor to say, hey, look, this is what's going on. Not always are judges selected based on political affiliation, but remember, it's more about your actual selection process for what you actually want the judge to rule on and so forth. And one thing we have to remember too is, even though generally when a president selects a judge, and they usually do it on the idea and understanding that they're most of the time are going to rule on the side of what they actually want, there are times where judges have been appointed, whether it's by a conservative or more liberal president, and are thought to follow kind of the similar beliefs, but actually don't. And you have to understand, it's difficult to predict for a few reasons. One, because you don't necessarily know these people personally. 2, their job is to interpret the law, and their interpretation of the law can also be influenced by their other justices and also what's going on in the country at the time. One example was Chief Justice Earl Warren, one of our most famous ones. He was actually appointed by Eisenhower, who was conservative. He thought he was going to be a conservative justice, but he actually turned out to be one of the most liberal justices we've ever had, and was very instrumental in a lot of cases that actually brought about like things like for the civil rights movement and so forth. And that kind of is a good example to show you it's difficult to predict that these justices will just kind of have the similar understandings and beliefs of the president that appoints them, but most of the time they do. Um, Another thing too with justices, they or the process that goes into it, there is a very close relationship with the attorney general to actually put together the list of nominees and for who should actually be considered. Now, another key process or key player in the process of selecting a justice is the American Bar Association. And the reason why this is they're not only just the largest national organization of attorneys for our country, but generally our presidents use them to um, get a list and kind of get a background of who might be the, not only possible people to put forward for the Supreme Court, but possible people who could help them make that selection and evaluate the actual professional qualifications and careers that everybody's had. Generally, they're basically an advisor to help with the recommendation process. Now, some other things that go into other factors that go into appointment is you do have interest groups and lobbyists and agencies, as well as the media, can even influence the courts themselves, whether it's just the court and its actions or the actual appointment process, and so forth. Now, the role of our justices, the role of each justice actually on the Supreme Court can actually help influence too. They can influence in a number of ways outside of just the cases themselves. They can actually influence the appointment of new justices by, like, for example, writing a letter of recommendation on their behalf, or even in the case of actually lobbying for somebody. Although this doesn't happen very often because most of the time in our history, if somebody's on the Supreme Court, they want to stay out of the news because they don't want their opinion to look, they don't want their position of being, um, even-handed, taken away from them. They want their rulings to be trusted, and they don't necessarily go out into the public and lobby too much. The one big example against this, though, is William Howard Taft, our former president, who actually, after he served as president, became a chief justice of the Supreme Court. He actually ran a public campaign, but that's a little bit different considering that he was somebody that was used to running campaigns to getting elected. Because, I mean, think about it, he was president before. Now, Sandra Day O'Connor, we're going to talk about her real quick. This is our last slide. And we're going to talk about her specifically because she's the first female that was appointed to the Supreme Court. And not only that, she actually had a very typical career for somebody that actually was appointed to the Supreme Court. So it's really important to kind of look at that as a kind of a typical background for a judge, but also the fact that she's the first female that was to the point of the Supreme Court is a really big achievement in and of itself. She was actually named to the Supreme Court in 1981 by Ronald Reagan, and she was from Arizona, and this was her career. And like I said, this is a typical career that a Supreme Court justice has before they become or be named to the Supreme Court. She was a lawyer. She was actually the assistant attorney general in the state of Arizona. She eventually went on to become an appeals judge in Arizona after she was a senator in that or for that state. So that's a pretty substantial, career in showing that she had a legal background, a very good legal background, and political background to be a member of the Supreme Court. All right, guys, that's all I got for you here in Lecture 3. I'll see you in the next one.